This is something that's really been needed. We've been bombarded with calls, and I'm sure you're getting bombarded with calls throughout the state. So we really appreciate you doing this. Before we start, the Greater El Paso Association of Realtors is devoted to enhancing the real estate industry in Texas. Meetings focus on promoting the interests of real estate professionals and consumers, fostering competition and sharing best practices. Discussions that violate antitrust laws, such as price fixing or limiting service offerings, are strictly prohibited. Thank you all. Lori, we'll turn it over to you. Thank you.
You're breaking off a lot.
Thank you, Tony. Yeah, Tony was breaking up for me as well. So if you are unable to hear me, or if it's breaking up, just let us know or put that into the chat. Thank you, Tony, for reading the antitrust statement. That's very important. Are we recording already, Kara? We're good on that? Okay. Hi, I'm Lori Leedy, General Counsel at Texas Realtors. I'm happy to be here today. I think we have over 230 people here. That is amazing. Thank you so much for being here. I'm so excited to be able to share information with you. That's the most important thing that we can do right now, is to get information in your hands so that you can educate and assist your clients well. I've got about 40 minutes of information, I think. This is not a contracts class, but I do want to go through the updates to the forms. That's the most important tool for you right now. I'm going to start with a little bit of background, though, on the lawsuit. Because there are so many of us on this Zoom, if you have questions, you're welcome to type them into the chat. I do not know that I will be able to monitor it in real time, but if I don't see a question timely and answer it, we can perhaps have a few minutes at the end to go back through and then ask questions at that point, remembering that there may be certain questions that I'm unable to answer. I like to say I not only don't have a crystal ball, I don't want to look into it. I don't like to answer questions where I'm required to speculate, because I don't want to create situations where you're repeating information that may or may not come to fruition. So my goal here today is to share information with you that we know, to remind you about some tools that we have for your benefit, and to kind of walk through a high level of the forms changes and tell you about what's going on here. So with that, I am going to share my screen, and give me just a second to make sure that I do this correctly. Can everybody see NAR settlement? I can't see you anymore,
Yes.
so you'll see it. Thank you.
Yeah.
I've got about 3 screens here, but
yes.
yeah, thank you. Okay, now I should be able to see you all. Don't know that hang on, let me see if I can also. I'm going to see if I can see the chat. Okay. So let's start with, and I'm not going to go through all the slides, but I do have this PowerPoint, so much better to look at it than me. So I'm going to use most of the slides here. I do want to give you a little bit of background just in case you haven't been paying attention. Over the last few months, everybody I think knows that NAR had been sued back in 2019. There were a few different lawsuits going on. Some brought by home sellers, some brought by home buyers, some brought by competitors out in the field, but all generally dealing with what we call antitrust, where the plaintiffs are claiming that actions or rules of NAR have precluded competition in the field, and the result was inflated commissions for listing agents and buyers' representatives. It's kind of the gist of what we're talking about here. The first suit to go to trial is what we call the Sitzer-Burnett lawsuit. That was a suit brought by home sellers in the state of Missouri. Now, I say it's in the state of Missouri, but it was a federal case, so it was still a big deal. And there were a few plaintiffs who were able to achieve what's called class status. That means that in that lawsuit, those plaintiffs got to call the shots, but any outcome had the potential to impact many, many, many home sellers nationwide. There were dates that were set, and if you sold a home in certain areas in those states, you could potentially be included. I like to remind people that class actions do serve a good purpose in the litigation world, but they also um, many of the class participants end up getting pennies on the dollar if they participate in that. I tend to get notices from insurance companies or I was going to say long distance providers, cell phone companies, big entities like that, where, hey, there was a lawsuit and I can participate in this. I would get about $2. So it's kind of what we're talking about here. This lawsuit was filed, the Sister Burnett lawsuit was filed back in 2019. It did go to trial in 2023, and they had 11 days of testimony. NAR put up arguments about, they brought in economists. There was a lot of detailed information about the market, about how commissions work. After 11 days of trial, this jury took 4 hours to find against NAR and the other defendants. The damages that were assessed were in the billions of dollars. Anytime there's a class action suit, or specifically an antitrust class action suit, there's the opportunity to treble damages, which means we're basically tripling them. So we're looking at billions of dollars. At that time of the verdict, which was Halloween of 2023, NAR did begin motions to file to get that verdict turned over. There's a few different options that you can take at that point when you've lost at trial, and NAR had started down that road. At the same time, they began negotiating with the plaintiffs to get this lawsuit settled. Fighting the lawsuit was financially irresponsible and could have potentially bankrupted NAR, leaving the other defendants wide open. With this settlement, not only were the named defendants in the lawsuit covered, all members of NAR, that includes you all, local associations, state associations, and many MLSs were also covered. So this is a good thing for the industry. We get to move forward. I know that change is hard, but looking at this screen here, the 3 bullets at the bottom are the reasons for the settlement. NAR felt good about the fact that they were able to preserve compensation to buyer brokers. Had they appealed this, we just don't know what direction that would have gone in. So this is where we are in the settlement. I am going to move to this timeline. So the settlement was announced on March 15th. I should back up a moment and let you know that prior to that March 15th announcement of the settlement, as soon as the verdict was announced nationwide on Halloween, copycat lawsuits were filed. And that means there are other plaintiffs out there with other law firms who saw this as a good deal and literally took the original plaintiff's complaint that had been filed in the original lawsuit, cut and pasted, put different names on it, and filed them in other courts. 2 of those copycat lawsuits were filed here in Texas. I know that Paso was named along with Texas Realtors, along with about 11 other local associations, and I think we were at over 30 brokerages. Those 2 lawsuits that were filed in Texas were consolidated, which was a good thing, means that we all only had to fight 1 lawsuit. And that case is on hold right now. So the idea is that even the plaintiffs and all of the defendants in our Texas case are participating in the settlement. The settlement is not final yet. So look at this slide for a moment with the announcement on March 15th. We've already passed June 18th. That was a deadline for certain parties to sign in to participate. And the next big date is August 17th. That is the date by which NAR set for all MLSs to be in compliance with the settlement agreement. We'll talk about the settlement agreement, the specifics in a moment, but all of those requirements fall to the MLS to enforce. So NAR chose August 17th as that deadline, even though if you look to the right of that, it's really a September 16th deadline under the settlement agreement. The one thing that you do need to note on this slide is that November 26th, there will be a hearing in Missouri in that federal courtroom. And that is where the parties will go back to the judge and let the judge know that we all intend to still move forward. The judge at that point has to determine whether or not he is going to finally give final approval to the settlement. A lot of folks ask, why are we doing all this work now when we don't have the settlement finally approved? That's because the settlement agreement requires us to do that. We have to show that we are moving in the right direction. We are implementing the changes agreed to. That is what gets us to that approval. So just want to make sure that we are clear on that. Okay. I already talked about some of this. Some of the important changes that you are being impacted with is that MLSs have to remove all compensation fields and prohibit the sharing of compensation through the MLS. That's a big change, but that is the gist of what is going on here. MLSs also have to prohibit its subscribers and participants from using data feeds for that purpose. You are already not allowed to do this, but you're not allowed to filter out or restrict MLS listings based on levels of compensation. That was something that had previously been done. So you're going to see changes if you're not already. And I'm sorry, I don't know exactly what your MLS has done or will do, but MLSs are removing the compensation fields and adopting the rules changes that came down from NAR to prohibit any sharing of compensation or even any reference to compensation in the MLS. In addition to that, the settlement agreement requires all MLS participants to disclose certain new disclaimers to sellers and buyers. And as an MLS participant, if you're working with a buyer, you have to have a written agreement with that buyer prior to touring a property. These are some pretty big changes for all of us. But the point I want to make with this is that that onus, that burden for enforcement of this is on the MLS, and it will be done at the local level. So the most important takeaways are that broker compensation is not set by law and is fully negotiable. That phrasing has to be in all representation agreements going forward. We did have some language similar to that in our agreements, but we have updated our forms to put the specific verbiage in there. For sellers, you all as listing agents have to disclose to the seller and obtain seller's authority for compensation or offers of compensation that you as a listing broker or the seller would offer to a buyer's representative. We'll talk about that in more detail. And then for buyer written agreements. So you have to have a written agreement when you're working with a buyer before you tour a home. In Texas, we say showing. So we're going to change that word touring to a showing. Working with a buyer means providing brokerage services to a buyer. It doesn't mean if you are working on behalf of the listing agent. So if you are the listing agent and you're holding an open house, buyers that come through that open house, you do not have to have a written agreement with them to show them. But if you are not working on behalf of the seller, you would have to have a written buyer's rep agreement before showing a home. And a home has been defined to mean a 1 to 4 family residential dwelling. We're going to talk about that one as well in a moment. So with this agreement, I mentioned earlier about what NAR did preserve is the ability for buyers, brokers to be paid. They can obviously be paid directly by consumers, a buyer or a seller. They can be paid through seller concessions through the contract. We already have in the 1 to 4 family contract, paragraph 12, that is a seller paying for certain expenses of the buyer. Right now, that language does not cover buyer broker's fees. TREC is considering the language to add that though, but under the settlement, the point is that a seller could pay additional fees to cover buyer broker's fees, and that could be handled in the contract. And then listing brokers can still offer compensation. They just can't do it on the MLS. So it's a little bit interesting. This lawsuit was brought by home sellers. The idea was to bring more transparency and opportunity for negotiation by sellers. But some of these changes do seem like you're going to have to make more of an effort so that it is transparent, because you're no longer communicating offers of compensation on the MLS. You can do so on a yard sign, you can do so on your website. I joke that we're going to have to get our fax machines down from the closet and communicate that way, just no longer on the MLS. So, what I want to talk to you about are the Texas Realtors forms that we have already updated. We put them out on June 24th. They can still, the updated forms can be used even if your MLS had not updated its rules yet. So even if you currently still have offered compensation required by your MLS, which can be so for a few more days, about 11 more days, if I can do math, it's okay. Our updated forms, there's nothing missed there. You can still do that. But we wanted to get the forms out early because we did not know exactly what date MLSs would be changing their rules and their fields. Some MLSs took an interim step of just removing the requirement to offer compensation, and then took a second step to remove the fields, and others are doing it in one fell swoop. Some did it August 1st, and some are doing it August 16th. So I just want you to have that information so that you know why we did what we did with the forms on the timing that we did. We've updated all of our residential listing agreements as well as our buyer's representation agreement. We've updated the amendments to those. We created a new short form buyer's rep agreement, which we'll talk about, as well as an addendum to the TREC contract, which is intended to help you explain and memorialize broker compensation in a way that had not been done before. We also updated our other compensation agreements where a broker can be paid from another broker or from the seller directly. So let's talk about these. Like I said, it's not a contracts class, but I am going to highlight the changes so that everybody at least has that basic understanding. And I highly recommend that you take a 2-hour class on these changes so that you can understand them better. This 2701 that's on the screen is a brand new form. This is intended to be an easy button. I said that our previous representation agreements did have language in there about commissions, but it wasn't the exact language that the settlement agreement requires. You can see it here on this page. If you have a client and they signed a pre-June 24th buyer's rep or listing agreement, you will need to update that if that client has not gone under contract to buy or sell a home prior to August 17th. So if it's August 17th, your client had an old representation agreement, you can use this new TXR 2701. It's one page only. And all it does is get you in compliance with the settlement agreement. You're also welcome to just amend your representation agreement, because our amendment, which is right here, 1404, does get you there. But we thought it might just be easier to call it out with this special new form. This will go away at some point. That population will get smaller. Those of you that signed pre-June 24th representation agreements, there just won't be as much of a need for this. But this is the easy button to attach to your agreements, and hopefully your clients, you'll talk to them, explain what's going on, explain that this adds disclosures for their benefit, talk to them about what the language means, and have them sign this. I want to spend a minute talking about our listing agreements. So what is on the screen is 1101, but this applies to 1101, 1102, and 1201, which is our farm and ranch. We've been getting that question a lot about leases, farm and ranch. The settlement agreement applies to buyers and it applies to residential property. But because the forms are written in the way that they are, we also updated 1102, which is our lease listing agreement, because that agreement dealt with compensation on the MLS. So we've updated it simply for that purpose. Now, with respect to farm and ranch, settlement agreement, as I mentioned earlier, talks about residential property being a 1 to 4 family structure. Here in Texas, when we talk about farm and ranch versus residential, we're usually talking about the intended use of the property. There's not really a definition of farm and ranch versus 1 to 4 family. I know that for lending purposes, it might be based on the appraised value of that home versus the land. It may be based on the acreage, but there's not really a legal definition to differentiate 1 to 4 family from farm and ranch. But per the settlement agreement, any 1 to 4 family. So even if that home is on a farm and ranch property, so you're using the farm and ranch listing agreement and sales contract, we think that, and NAR agrees with this, that it needs to be in compliance with these updated rules. So all that is to say, we went ahead and updated 1201 to include the required disclosures. Paragraph 5 is the biggest change on the listing side. We moved all the language that had been spread out in that agreement to one place where it deals with broker compensation. It used to be broker compensation in one place and then sharing of commission with buyers' representatives a few pages later. It's all in one place now. A and B are the difference between a seller authorizing their listing broker to offer compensation or not. So paragraph 5A works the same way. It works under the MLS in that the seller pays the listing agent or the listing broker an amount, and out of that amount, that listing broker is going to offer buyers' representatives compensation, just not on the MLS, but they are authorized to offer it. 5B is the seller saying, I want to pay you, listing broker, but I'm not ready to say or to give you money to offer to buyer's agents. I hope that listing agents will have that discussion with their seller, the seller needs to make that decision. The sellers need to understand that if they're choosing 5B, they may get approached by buyers saying, hey, here's my offer. Along with my offer, I need you to pay for an amount to go toward my buyer's agent fees because I'm a first-time home buyer. I'm any kind of buyer that can't afford to pay buyer broker's fees. So I'm asking you to do it. So that is why we have the note under B, so that the listing agent can discuss that idea with the seller. And then we direct you to 11F, where the seller can authorize the listing broker to let other brokers or potential buyers know that the seller might be willing to offer buyer's broker compensation. I don't think I have a photo of it. I don't. But note that 11F, which is at the bottom of the page, is new. This is different and unique from paragraph 11D4. So just above 11F in the listing agreement is 11D4. 11D4 is what authorizes the broker to advertise cooperative compensation. 11D4 is referring to the broker offering compensation out of amounts paid to the broker, so a 5A situation. 11F is a 5B situation where the seller is offering potentially buyer's broker's compensation. Now remember that even if your seller has checked 5A, the broker and the seller are agreeing under 5A2 that there will be cooperative compensation offered by the buyer's broker. Nothing in here, though, obligates that listing broker like the MLS did. You all recall that the MLS had previously a unilateral offer of compensation and it was enforceable. That does not exist anymore. But this listing agreement is a discussion and an agreement between the listing broker and the seller as to how that's going to operate. It's not going to function as an agreement between the broker or the seller to that buyer's agent to pay that money. I'm going to admit it, a lot of this is just going to, through practice, as you get used to this new way of doing things. These forms are intended to help you get there. If your seller has chosen to go the 5B route and does not want to offer compensation immediately through the broker, but maybe they want to see what kind of offers they get in, 1412 is an updated form for your benefit so that your seller can then authorize you as a listing broker to let potential buyers know that, hey, this seller is willing to consider contributing this amount to buyer broker fees. We have a blank in there, you can put a dollar amount in there. Again, this doesn't bind the seller to that buyer's broker, but it does bind the seller to allow the listing broker to advertise that. There will still have to be negotiation and a separate written agreement after that. I mentioned the amendment to the listing agreement earlier. This is simply just updated to track the new language that's in the listing agreement. So now that there are specific requirements for seller authorization of amounts, we want to make sure that you have the ability to update your listing agreement if that changes. So we have drawn it out. We don't want you to have to use paragraph F here at the bottom as you would have. You now have C and D for specific changes to compensation. Texas Realtors Form 1417 is also an updated form. I'm not sure it's one that was used very often before. There's always been a requirement at a certain point for you to disclose if you represent a party. That could be done verbally, though, orally or in writing. So we had this form, but because it wasn't required previously for it to be in writing, I don't know if it was used. We updated this because we think that now that a written buyer's rep agreement is required, you as listing agents may want something to confirm to that buyer that you're talking to. Perhaps you got a call off the sign and you go open that home for that buyer, or you're holding an open house. You're going to want to use this form so that the buyer can see that you represent who you represent in the transaction. That's all this is kind of a CYA form updated for you to use in those purposes. Let's talk about buyer's representation agreements. There's also numerous changes here that I want to make sure that we cover. I am looking, I cannot see the comments anymore, so I apologize if there are questions coming through.
El día que estaba haciéndolo estaba con ella, y luego, pero no más. A Diana, al último le dije porque
I think somebody needs to mute.
she saw me. Lo dice Juan.
Can we mute? Okay, we got it.
I transferred up there.
I am. Okay, are we good now? I am seeing a question in here. What if it's your listing and a caller has to see the listing? And what if they do and don't have an agent? Whether or not they have an agent, it's not going to matter. If you are a listing agent, you are working on behalf of the seller. You will not need a written buyer's rep agreement. Commercial properties are not impacted by this. This is only for residential in the purchase of a home, so there's no impact there. And there can still be the idea of unrepresented buyers. Let me go back to the listing agreement for just a moment. I will mention to you that we are updating this form one more time in the next week or so. We are looking at clarifying fees under paragraph 5 to cover scenarios where you as a listing broker are either an intermediary or a transaction where the buyer is just unrepresented. We have been getting feedback that for the seller that chooses 5B, it's challenging to go back to that seller and have that discussion about intermediary because you already have an agreement with the seller. So you're not necessarily going to, you'll also have a buyer's representation with the buyer, but you need an easier avenue to have that discussion about intermediary with your seller, and it should be referenced here in the listing agreement. So we are looking at a change to cover that. Also, to deal with unrepresented buyers, because we know that in both of those situations, whether it's an unrepresented buyer or it's a intermediary, that the listing firm is doing a lot more work. And so we want to make sure that you're able to have that conversation with your seller and determine the appropriate compensation for those different scenarios. As I'm going to talk about buyer's representation agreements, let's go ahead and talk about this question. What about an agent holding an open house for another agent from a different brokerage? We are running into a lot of issues with this. It's my understanding that there are apps out there that make it very easy for agents to either do a showing on another agent's behalf or even hold an open house. If you are not working on behalf of the seller, you're going to need a representation agreement with that buyer or those buyers that come into that open house. It is possible in Texas that you are a subagent of the seller. So you have the listing firm that has a written listing agreement with the seller. It is possible for an agent from another firm to be doing work in that transaction on behalf of the seller. You're a subagent. The issue there is that you can't just call yourself a subagent and say, I'm working on behalf of the seller. I don't need a written agreement with the buyer. You have to have authorization from that listing firm. And you have to truly be working on behalf of that seller. I think anyone in that scenario needs to ask themselves why they are doing that. Are they really doing that so that they can get additional buyer clients? They're not working on behalf of the seller. We are in communication with TREC regarding subagency because some of these questions we've just never had to think about before, the way that it works. There may have been some situations where it was unclear who that agent was working on behalf of. Now we need clarity because now it makes a difference and you'll be in violation of the MLS rules without that. So we're continuing to talk about that. And we will be putting out additional information as we have it. But please know that unless you are the listing firm, an agent in that firm, or a sub-agent of that firm, which does still go through the broker, you will need a written agreement with the buyer. So you can see here in our buyer's representation agreement, we added the appropriate disclaimers about compensation being fully negotiable and not set by law, etc. We also spell out how much the broker's fee will be. It continues to work the way that it did, in that the broker will seek to obtain payment elsewhere, and the buyer's only on the hook if the broker's not able to do that. What is different here on this next slide is we used to have language in here about bonuses or additional compensation. We had to be very clear about this. The amount of money that a buyer's broker makes in a transaction has to be spelled out for the buyer, and they have to have signed off on that. So you have to have a written agreement with the buyer that you are making a specific amount of money. So we cannot just say whatever the listing broker's offering. We cannot say 2.5% plus any bonuses. That amount has to be what's called objectively obtainable. Objectively ascertainable. And so there has to be a specific agreement saying that the buyer's agent is receiving this amount. It can still be a percentage, but it has to be an amount that is determinable. So that's why you see this new language here regarding bonuses and other compensation. Because of that, hold on. We have updated 1505, our buyer's, the amendment to the buyer-tenant representation agreement. We want you as buyer's agents to have that discussion with your buyer, have an agreed upon amount. And if for some reason in that transaction there is additional compensation, perhaps a bonus, use 1505 so that your buyer can authorize you to receive that amount. It does not matter that that buyer is not paying it. The buyer has to agree to it. We needed to be careful because we know that when the buyer is agreeing to an amount that you will receive, they're on the hook for that if you do not get that elsewhere. We're not trying to penalize the buyer at all. So this 1505 has a new purpose for you to keep you in compliance with the new terms of the settlement, so your buyer can authorize that. I'm going to go back up now to our new form 1507. I've got the whole form on here for you to see. I hope you can see that. These are all on in zip forms and with all of our vendors. They're also on our blank forms page. But here it is in front of you. This is a brand new one-page buyer's representation agreement. Because it is one page, it's not going to have all of the same protections in it that our 5-page buyer's representation agreement has. Please, brokers, talk to your agents, and agents talk to your brokers. Is this a form that your firm wants to use? There are some brokerages that are not using it. They like the 5-page and agreement and all the protections that it has. This one-page agreement is intended to satisfy the request that we had been receiving for a shorter buyer's rep agreement. In addition to that, if you look at paragraph 5, this form provides you a choice. You can use this one-page form just as you would the 5-page for full services. You're representing that buyer to purchase the home. The second box under paragraph 5 says showing services. This is for the purpose of you just want to show the buyer that home, or maybe more than one home, and you need to satisfy the requirements of the settlement agreement and have a written agreement in place. You can use the box that says showing services. I'm just here as an agent to show you this home. I'm not an agent in the listing firm, so therefore we need a written agreement. You can put $50 in that blank. You can put one home, you can put one street, you can put one neighborhood. This short form is intended to allow you to meet the settlement agreement and have the buyer sign something much, much shorter than they would have to otherwise. It does have all the required information. It also has intermediary in here because we know that still may be an issue. If your buyer signs this and your term is 1 day and your property is one home, and the next day that buyer says, hey, I really like that house, I want to make an offer. Will you make an offer on it for me? You're then going to need to sign another agreement because this agreement's done. It's over. Maybe you're in the home and the buyer says, hey, I want, and your buyer injects showing services, but you're still within the agreement terms, and the buyer says, hey, I want to buy this home. You're going to either want to amend this to move to full showing services or sign a new longer agreement. Our updated 1505, which I showed you a moment ago, will allow you to move from showing services only to full services. Now, if you are offering showing services only to the buyer and they start asking you questions or having other conversations with you about purchasing that property, you are required under the License Act to answer their questions. You're not allowed to withhold any material information. You have fiduciary obligations. Even as a showing service only agent, you still are obligated to those fiduciary requirements. So we like to call them our minimum duties, even though you're doing limited services. I hope that makes sense. Let me see if there's any questions on the buyer's rep side. We do not have forms right now for sub-agency, but we are considering that. And you only need one form with a buyer. You can choose to either sign the short form or the long form. The only issue is going to be if you use the short form and sign showing services only, you're going to need to amend that if you then want to represent that buyer further. You're not going to be able to go under showing services only and ask for cooperating compensation from a seller or from a listing broker. You're going to need to be providing full representation for the purchase of that home. We did update both 2402 and 2401. These are our compensation agreements. These can be used in place of the MLS. So we previously had a unilateral offer through the MLS that was enforceable. We're not going to have that anymore. This 2402 form is enforceable. You can use this to submit a request for the listing broker to pay your fee as the buyer's broker. And when you and the listing broker sign this, you now have an enforceable agreement. If any issues came up later, you'd be able to arbitrate that through Texas Realtors. So this 2402 is one opportunity for you to replace that MLS offer of compensation. I don't have a picture of 2401. I apologize about that. That is the compensation agreement between broker and owner. Now that agreement and this one had already existed. They were called registration agreements. Perhaps you used those in your practice. We updated the name to be a compensation agreement. And for 2401, that was a form that perhaps you as a buyer's broker would use for a FSBO, for sale by owner. It's the same situation. You can be asking that seller to cover your buyer's broker's fee and pay you directly. They are still represented by a listing broker, but they're going to pay you directly. You can use 2401 for that purpose. And here comes the real fun. 2406. This is a brand new form. And our intent with this form is to allow you as brokers to memorialize broker compensation. That's why it's called addendum regarding broker's fees. I mentioned TREC earlier. Let me do a little sidestep here and talk about TREC. TREC is aware of the changes to the practice of broker compensation based on the settlement agreement. TREC is considering updating their forms to reflect that change. TREC, being a governmental agency, moves a lot slower than we do. If TREC does update their forms, it will be probably January 2025 before they're out there for your use. And that's just because they have to first propose forms, get public comment, and then they can adopt them. They only meet 4 times a year. So think about that being at least a 3-month process between meetings from when they proposed the forms to when they adopted them. The TREC forms currently still refer to MLS offers compensation and do not currently offer a way for seller to cover buyer broker's fees in the contracts. For that reason, as a stopgap, we created 2406. I am hearing that some members think it's a little bit confusing, but let me walk through it real quick. The only additional obligation in here is in paragraph D, and that's D1 or 2. That first line in D and C are referring to previous agreements. The listing broker's fee in paragraph C, that's just there so that everybody understands that there is an agreement between the listing broker and the seller, and that the listing broker's compensation is going to be paid out of that. The beginning of D is the same way, but we wanted to offer a way for that buyer's broker to receive compensation either from the listing broker or from the seller here. D1 refers to 2402, which I just mentioned a moment ago, as our compensation agreement between brokers. So it's intended that D1, you're just reflecting the amount that's in that separate agreement. This form is what brings that 2402 into the transaction, because this form, the seller and the buyer are signing. If you're using 2402, only the brokers are signing that. So this recognizes that it's out there and brings it into the transaction. D2A is the same way. It is respecting the fact that there is a 2401 agreement that's been signed between the seller and the buyer's broker. And so those blanks are intended to be filled with whatever is in that separate agreement. And then D2 is the only new obligation created without a previous agreement, where the seller can agree here in D2 that I will pay the other broker, the buyer's broker, a certain amount. So we've got appropriate caveats in here about what is for informational purposes and what creates a new obligation. And we also repeat in here that broker fees are not set by law and that they're fully negotiable. This is intended to help. We have been meeting with title agents as well. They really like this form because they want to know that the parties are clear on the instructions they've been given as to how to pay out compensation. Lenders, we've been talking to them too, and they're pretty comfortable with the direction that we're moving in as far as additional seller concessions. You all know there are caps under certain lender requirements as to what a seller can pay. As long as we keep that buyer broker's fee separate from the other amounts seller may be paying, they like that. We have to be careful there though, because if your MLS is going to create a field for seller concessions, that is allowed. But any amount put in the MLS under seller concessions cannot be tied directly or limited to buyer broker's fees. So there's a discussion occurring on the MLS about concessions, and then discussions outside of the MLS about buyer broker's fees that can be part of those concessions. But I think they'll be dealt with separately in the agreement. TREC is looking at adding another concession line in paragraph 12 to deal with buyer broker's fees. They are also considering adding language to the contract, just like is in the farm and ranch currently, where the buyer and seller agree to what they will pay. That is, I'm at the 45-minute mark, so I'm going to stop there. I'm going to stop sharing my screen if I can get back there easily. And then I'm happy to try to take additional questions. And then back. I'm going to go backwards here just so I can get to some of these. And I'll apologize now if I can't answer any of them, because either I don't know the answer yet or I don't want to answer that yet. But there's no requirement that you use 2401 or 2402. Here's the issue that you all are going to have to contend with. You now have choices. You have many avenues to get you compensation, especially as a buyer's broker. You have many avenues to get there, whether it's the buyer paying directly, the seller paying directly, the seller signing 2401, or it being dealt with through a concession agreement in the contract. So while I'm proud of the fact that we are able to provide you all these opportunities for you to discuss with your clients, I do know that that is going to be challenging on your part, because as brokers, you're going to have to make decisions on how your firm wants to operate in this new world. As listing agents, are you going to talk to your sellers? Maybe you want to take listing broker offer compensation off the table and tell your seller if that's something they want to consider. You can do that through the contract. So there's many, many choices now that we just didn't deal with before. So there's nothing that is required here. There are things that are prohibited here, and that is offers of compensation on the MLS. I'm looking at some of the questions. I think I've answered most of these. Tenants are not covered by this agreement, only buyers. I will tell you though that NAR is siding on the side of being conservative. And so they're looking at putting out additional guidance as to you as MLS participants, how far these requirements go. So is it you as an MLS participant, or is it dependent on the property type? So we are hoping for some more guidance when we are outside of the typical buyer touring a home for sale situation. If you're only showing property, I think that is an issue you need to discuss with that buyer of how you're going to get paid. I think brokers need to determine how their agents get paid in those situations. Remember, all compensation goes through the broker. So even if you're only getting paid $50 to go show a home, that goes through the broker. Does the broker want to allow you as an agent to use Venmo or some other app for that purpose? I don't know how popular this is in El Paso, but I know in some of the other areas of the state and the bigger cities where it's challenging to get across town, or even in rural areas where properties can be far apart, there are agents offering to serve as the showing agent. And so you all need to think about payment in those situations. I can tell you what would be allowed and not, but I can't tell you which route you should go because, like I said, got more opportunities now. I'd rather have questions typed in, not live, because we are recording this. I don't want anything that is inappropriate asked and to be recorded. There is no requirement that, as for example, a buyer's broker, that you show your representation agreement to the listing side. I do understand that it's concerned now. I think it's going to be up to each agent independently to ensure they are in compliance with the requirements. So the question is, as a listing broker, your buyer's agent is asking for a certain amount of compensation. How do you know that that buyer authorized that broker to receive that much? I think it is up to that buyer's broker to ensure they have appropriate authorization from their buyer for whatever it is they're asking as compensation. Do the farm and ranch land listings without a home on it also need to use the new forms? No. We did update the farm and ranch listing agreement though, so you will be using updated forms, but this applies only when there is 1 to 4 family home on that property. And what a great question. Are there any kind of public education going to happen with respect to this lawsuit? NAR has just begun and Texas Realtors is about to begin. We are putting a lot of money toward publicizing, not necessarily changes, but ensuring that consumers understand compensation and transparency and the value that remains in using a realtor. So yes, you're about to see an onslaught of consumer campaigns and campaigns for you all as members to understand what's going on from both entities. So please be on the lookout for that. That will be starting very shortly. There's a lot of questions in here, like if an agent is the buyer or the seller. There's nothing in the settlement agreement that says, but not in this situation or not in that situation. Settlement agreement is unusual for us. It is an agreement between parties that basically is the law of the land now. And so it's not like they sat down and thought about all of these other issues. And because we need to be in compliance with the settlement agreement, we want to see everybody acting within the spirit of it, not just the letter of the law. And so even if, let's say, somebody who wants to tour a home is a different licensee, you still need to comply with the terms of the settlement agreement. A buyer's agent can receive compensation from more than one person. So the buyer's agent can be compensated by the buyer as well as that listing broker. That might happen if the buyer authorized their agent to receive a certain amount of dollars and the listing broker is only offering so much. That is okay for that buyer's agent to be paid from more than one party. I want to mention that the magazine that you're going to receive this week has basically the information I went over today. It's got the guide to the forms changes. In addition to that, on texasrealestate.com, we have a landing page. I believe now it's called NAR Settlement and Your Business. We have a ton of FAQs there. We still have the red lines to these forms changes so you can see those changes. We've got videos there for anything specific that we really need to clarify. We've recorded a 2-minute video. So if you like to digest information from reading, look at the FAQs, from hearing, open the videos. Please keep going back there for updates. Those questions are coming in so fast that I cannot even see them. Once we end this session in a moment, we are going to capture the questions. I believe Kara will be able to still see those questions. They'll be recorded, I guess. And we will make sure that any question that is not already answered in our FAQs or otherwise in a video, we will get that answer. And I can even send Tony the answers that he can share with you all. This does apply to builders, even when a builder is a seller. This applies to any MLS participant showing a home. Thank you. Kara put the link to our webpage in the chat. Please go click that before we end this. And anytime you're talking about linking from the MLS, we want to be very careful. We cannot utilize the MLS to share offers of compensation. I believe there has been some guidance recently about you're still able to offer compensation on your webpage, even though you have an IDX coming in there. That's okay. Can't be utilizing that IDX feed to populate offers of compensation. I am going to end it here. Just remember, you can advertise offers of compensation still. You just cannot do that through the MLS or utilizing the MLS. Go to our webpage where we have all of this information in the red lines of the forms. Call our legal hotline. If you have specific questions, they can direct you to where a specific answer might be in an FAQ. And then we're going to share this recording with Greater El Paso Association with Tony, and you'll be able to access it. Thank you so much, everybody. It's been a pleasure to be with you this morning.
Thank you so much, Lori. We really appreciate your time.